What we know is a drop. What we don't know is the ocean.
Hello, and welcome to the Newton Knowledge Podcast. My name is Mark Singer, partner of Newton One Advisors, and I'm joined by our managing partner, Steve Target. The Newton Knowledge Podcast will provide meaningful content to our valued advisor community. Our discussions will deliver unique insights into the people, processes, and products that make our industry so critical. Newton One is a national life insurance planning firm delivering customized solutions structured to help clients and their advisors engaged in solving estate planning, wealth transfer, business succession, and executive benefits challenges. We are a member of the M Financial Group, which grants our clients access to the nation's elite carriers and exclusive products available only through our network. Thank you for having us, Marty. We appreciate it. Thanks for letting us come in.
Thank you for letting BNY be represented on your podcast.
You have a beautiful office. How long have you guys been here?
Gosh, we've probably been here for several decades, I would think.
Okay.
In this building.
What's the original name of the building?
I don't know.
Isn't this referred to as the Mellon Building?
Yeah, it's been the Mellon Bank Building for I think decades.
For our audience today, we're with Marty Babitz, Senior Wealth Strategist at BNY Wealth. Can you tell us a little bit about your career as well as what you currently do and your primary focus is with BNY Wealth?
Yeah, sure. Mark, Steve, thank you for having me. I have spent the last 38 years since graduating law school as a wealth advisor. I practiced law for the first 11 years as a trust and estates attorney and tax planning and attorney, working with closely held businesses on business succession strategies and liquidity events. And the last 25 or so years, I've been in the wealth management world. I do very similar work from a different perspective. I work in conjunction. I try to look at myself as a catalyst and a collaborator. If we can help our clients and mutual clients with their other advisors come up with potential strategies that can advance their goals for themselves, their families, and their businesses, which can include tax mitigation, asset protection, and other strategies for themselves and their families. We can hopefully get that to the next level, which would be, to their other advisors, their tax advisors, their legal advisors, their insurance and other advisors to perhaps vet and implement those strategies. So that's where the collaboration comes in. And I think the case we're going to discuss today has a lot of those elements in terms of cautions for the unwary client who doesn't work with a team that collaborates and focuses on the areas that they have expertise in.
That's a great point. And Steve and I are contacted daily, being a piece of the collaborative team from an insurance planning standpoint, mostly by business owners preparing to sell, essentially, and what proper planning considerations should take place that could have huge effects on what they essentially receive, tax planning, their legacy, all the types of considerations that we want to be part of a team to help facilitate that process. So recently, the tax court issued a ruling with the case we're going to talk about today, which involved the estate of Scott M. Hoensheid. This case regarding the sale of a business, which may clarify some of the recommendations that we as advisors may make going forward. But to start off, can we review, and by we, I mean you, Marty, the traditional approach for planning, charitable planning or charitable gifts for closely held business assets prior to the sale or liquidity of a business? What would be the traditional planning technique that you and your team would consult on?
Yeah, no, thanks, Mark. It's a great question, and I think the three of us agree that there's a narrow window of opportunity ahead of the sale of a business to do some planning that can really reverberate not just for the business owner, but for his or her family and social impact that they might like to make for many generations to come. And that opportunity can close pretty rapidly. Sometimes the planning is focused on family legacy, and sometimes it's focused on charitable or social impact, as it was in the Hoensheid case. This case involved a situation where one of the three owners of the business, Scott Hoensheid, wanted to get some of the equity in the business ahead of the sale of the business to charity. In this case, it was a donor-advised fund, and accomplish a couple of great planning objectives that could not be accomplished after the sale occurred. One was to avoid capital gain taxation on the portion of the equity that he wanted to set aside for charity in that donor-advised fund. Another was to obtain a charitable deduction for the value of the stock at the time of the transfer. And those strategies are terrific because you can get that double tax benefit of avoiding capital gain taxation and also getting the charitable deduction. In this case, somehow, by poor planning, neither of those strategies were accomplished. And that's why this is such an important case for all advisors to be aware of. But to your question, Mark, what is the traditional approach and strategy for accomplishing those twin objectives in the case of charitable planning ahead of a sale of a closely held business? And up until this case, the Hoensheid case, there was kind of a bright line test. At least we thought there was a bright line test where if a business owner were to transfer equity in his or her business to a charitable entity, let's say a donor-advised fund, as in this case, before there was a binding legal obligation on that charitable recipient to engage or participate in the sale of the business, then there would not be what's known as an anticipatory assignment of that income or of that capital gain by the owner to the charity. It wouldn't be considered as if the owner sold that piece of equity and then transferred the proceeds to the charity. And because charities are exempt from income tax and capital gain tax, that would mean that ultimately, if the charity did participate in the sale, that piece of the proceeds would avoid capital gains taxation. In addition, the owner could obtain, if all the proper steps were followed, which wasn't the case here, could obtain a charitable deduction for the value of those shares at the time of the transfer to the charity. So that's a typical strategy. And in this case, the client has seemingly received pretty good advice to make sure the transfer happened ahead of that binding legal obligation. In other words, before there was an agreement in place that locked in all the owners to sell the business to the third party.
So what's the impact then? You brought up the bright line test for assignment of income for future estate planning needs. What was the impact of the Hoensheid case?
Yeah. The impact of the Hoensheid case is pretty significant because it seems to blur or even eliminate that bright line, meaning that the tax court, this was a tax court case, the tax court essentially said, look, we're not going to follow previous precedents that established that bright line case. There were two very important ones. One was the Palmer case, which was a tax court case that kind of established that bright line test that we've just discussed. And there was also a revenue ruling in 1978, Revenue Ruling 78-197, where the IRS conceded to that bright line. What the Hoensheid case does is it says that bright line, that obligation to sell, if that obligation to sell on the part of the charitable recipient is not there, is one factor. And there are three other factors to be considered when determining whether there is an anticipatory assignment of that capital gain by the owner to the charity. So it makes it a little tougher because there's more planning considerations that now come into play.
Marty, you mentioned the one factor, and there was three others. Let's roll through what all four factors were in terms of what the court considered. Yeah.
So the court in Hoensheid said the first factor is still that factor of whether or not there was a legally binding obligation on the part of the charitable recipient to sell its equity that it received from the owner. And in fact, in the Hoensheid case, the tax court determined that there was not that legally binding obligation at the time of the transfer. So that was good. But there were three other factors that were outlined. One was what actions had already been taken moving down the road toward the sale of the business by the time the transfer of equity stock in this case had occurred to the charity. That was factor number 2. Factor number 3 was what remaining contingencies still had to be satisfied prior to successful closing of the transaction at the time the transfer happened to the charity. And number 4 was what other formalities had to occur within the organization, the selling company itself, before at the time that the transfer happened to the charity. So those additional 3 factors were what tripped up the taxpayer here and caused him to lose on those 2 key points of the assignment of income and the charitable deduction.
One of the things we talk about quite often, all of us do, is as you mentioned earlier, the earlier a business owner thinks about this planning, the better. Mm-hmm. So I think that probably applies in this case as well. But is there a period of time that really needs to be recognized as a minimum period of time to transfer that asset? Is it kind of a nebulous? It needs to be enough. Is it as broad as that, or is there anywhere in any rules, regulations, laws that stipulate, it needs to be at least 6 months or 8 months?
Yeah. Well, what's interesting, Steve, is that it does still seem that this is now a gray area going forward. Is there time? In other words, if the transfer of stock to the charity had occurred 3 months out of closing, or 6 months, or a year, would that have satisfied, all 4 of these factors in favor of the taxpayer? That's still unclear. What is clear is that you don't want to probably go nearly as far down the road as the taxpayer did in this case, because it was, as the court concluded, a virtual certainty, in the court's words, that the closing was going to occur, that this was going to be a successfully closed transaction, that there really weren't any contingencies that were going to trip things up. And the taxpayer himself had kind of hung himself by his own rope, because on the record there were several times where in written communications with his attorney, he had said, I want to make sure we are 99% there toward a successful transaction before we before we do this. And the reason was that he was one of 3 brothers that owned this business. They each owned 33%. And the concern was that if he made this transfer of a portion of his stock to the donor advised fund, and then the closing didn't occur, that he would be in a weakened position relative to his other 2 brothers. They would not be equal partners in the business. So he wanted to make sure, and he did, that they were so close that, again, it was a virtual certainty, 99% plus, that it was going to happen. It had become, in the court's words, remote and hypothetical that the closing was not going to occur. So we don't have
the closing was not going to occur. It was that the closing was not going to occur was remote and hypothetical. That's interesting.
That's right. There was one other factual dispute that was determined against the taxpayer, which was, when did the gift of the stock occur? And the court concluded that the stock transfer had occurred within 24 hours of the actual closing. The argument was that it had happened, over a month previously, and that might have saved the taxpayer. The problem is that there was all the paperwork prepared to make the transfer, but the taxpayer did not fill in the number of shares being transferred to the donor advised fund. Nothing was signed, so it was impossible to prove that. So the transfer was determined to have occurred just before the closing. At that point, as to those 4 factors we just reviewed, the only contingencies remaining were that there were 2 employees, one of whom was one of the brothers who owned the business, as to continuing their health insurance coverage for a period of time after the closing. That was the only remaining contingency. A very significant environmental impact contingency had been resolved a day or so before the transfer of the stock to the charity. And the only other formality was a signed agreement by the three owners, the three brothers, to approve the sale. But they had already, on the record, on the corporate record, unanimously approved the sale. And the court emphasized that this was a closely held family business, so that those types of formalities were almost like a given. They were clearly invested in the sale of the business. They had taken all other steps. They had agreed to the amount. It was a very, successful transaction in terms of some of the things we're seeing out there in the world the last few years in terms of some of the multiples for some of these transactions. That was definitely the case here. They sold the business for far more than what they expected they could when they first started investigating this. So they were invested in the sale. They'd taken all the steps. And that's why the tax court seemed to stray from that bright line, because they did, again, acknowledge that there was not a legal obligation on the part of the donor advised fund. In fact, the donor advised fund, a very major institution, probably the largest custodian of donor advised fund assets, had all the right kind of paperwork which said, look, we're going to take this stock, but it's our stock, and we can do with it whatever we want. We are under no obligation to participate in any kind of transactions. So they did all the right things. But the practical impact of what had happened was that they really, we're not going to be able to hold on to that stock. I think we all will concede that a donor advised fund, or most charities, when they receive closely held stock, it's like a hot potato. They want to get rid of it as quickly as possible. The means to do it were there. They knew within hours they would be receiving the cash proceeds from the closing of the business. So there was no way they weren't, as a practical matter, going to participate. These were the factors that the tax court emphasized in straying from that bright line test. One other interesting point was that the tax court said, look, we know that the IRS has a revenue ruling, the one I mentioned earlier, that commits them to that bright line test. But we, the tax court, are not committed to what the IRS has committed itself to. And we're going to, in this case, say that we're not committed to that bright line test. Now, they didn't go so far as to say we're throwing that out the window. They retained it as one of the four factors. And to your question previously, Steve, I think that if they had taken better care to actually physically transfer that stock, let's say a month or so earlier, and if the taxpayer in this case had not been so open about the fact that he wanted to make sure that it was a virtual certainty that closing was going to happen, that perhaps this might have flown and passed muster.
So I think we can infer. I think we can infer what we should be doing based on the things that were done incorrectly. But let's try and summarize. If you were advising a client who had some charitable intentions, selling a business, what couple things would you have that client do differently from a proactive, this is the right way to do it standpoint? Yeah.
Well, for one thing, ideally, we would advise the client to figure that if they're going to make this commitment to a charitable transfer ahead of the sale, which again is a tremendous planning vehicle because of those two tax benefits we mentioned, that they should be looking at it as if it's an irrevocable transfer. They're giving it, and they're not going to be able to get it back. This is part of their charitable and philanthropic objectives. Now, as a practical matter, they might be able to get it back. For example, in this case, if the donor advised fund had received the stock and the closing had not occurred, then the corporation or the individual stockholder himself could have likely redeemed the stock back, and the donor advised fund would be happy to get the cash. So not to be so open about the idea that you want it to be 99% certain that the closing is going to occur. And, of course, to have some time. Again, we don't know if that's 3 months or 6 months, but at least a couple weeks, a month, and ideally that there would be some steps that would still have to be taken. So what's the line, the gray area between a virtual certainty, which according to the tax court means you're sunk, or almost certainty? Is it almost? We don't know the answer, but we do know that you don't want to fly so close to the sun as the taxpayer did here. That's it's going to be a tough sledding going forward. And I think that many advisors now in these types of situations are going to err on the side of caution until maybe there's some additional authorities that come out on this and say, look, it's always interesting to see where very talented advisors come out once a case like this comes out. But I think my speculation is that a month or more of time and more contingencies than just employee health insurance for a couple of employees be still but dotted and taken care of.
So, Marty, I guess in addition to the assignment of income issue, Hohenscheid also raised concerns about charitable gift substantiation for charitable income tax deduction purposes and how that could impact other areas such as substantial understatement of income penalties. So how do planners help their clients avoid similar pitfalls when they're making charitable gifts?
Yeah, this was another key aspect of the case. We mentioned that the two keys of doing philanthropic planning ahead of a sale of a closely held business are, number one, avoiding capital gain taxation on the portion of the stock or other equity that's transferred to the charity. That was lost, as we discussed, because, again, the client, the taxpayer in this case, flew a little too close to the sun, got to that virtual certainty point, and the tax court decided that that was too much. But the other tax benefit is the idea of getting the charitable deduction. Now, we know you could still get a charitable deduction after the sale of the business by taking a portion of the cash proceeds and contributing them to charity, donor advised fund or otherwise. But to get the two benefits, you want to transfer that equity ahead of time. Now, when you're transferring something that is not cash, and it's more than $500,000 of value, as clearly was the case here. It was about $3 million worth of stock that was transferred to the donor advised fund. One of the requirements in the tax code, Section 170, is that you have to have a qualified appraisal. And in this case, the code requires that it be a qualified appraisal. And one of the things about a qualified appraisal is that certain forms be filed. There's a Form 8283, lays out all the detail of the valuation. But the other thing is that there be a qualified appraiser in order to have a qualified appraisal. And the tax code and regulations under the code section lay out a number of requirements that you might expect. You know, a certain level of expertise, professional designation, a certain level of education, the fact that the individual or firm preparing the valuation do it on a regular basis and receive compensation for doing so. Those factors were not met here. And this is a real other cautionary tale that's part of this case, because by all accounts, the taxpayer here had really good representation. Had a really good attorney, seemingly, although she did say, look, let's get this let's get this transfer of stock to the donor advised fund done as quickly as possible, well ahead of a binding agreement of sale. That wasn't followed by the taxpayer, clearly. And they had a great M&A team. It was evidenced by how, what the ultimate sale price was. But for lack of a better word, the taxpayer cheaped out when it came to the appraisal. His attorney advised you're going to need a qualified appraisal in order to substantiate the tax deduction. So he checked back with the M&A firm and said, can you do this appraisal? And the M&A team lead said, well, we don't usually do that. In fact, the M&A engagement agreement did not specifically say they would provide a qualified appraisal. But they said, we'll do it. I mean, they were being compensated very well, so they threw that in. They didn't charge for it. So that was one factor. The appraiser, which was the M&A team lead, really didn't have any experience on valuing closely held business interests. Certainly they did from the standpoint of trying to optimize the sale of the business, but not for this purpose. Did not have the proper designation or experience, and was not charging. So all of the requirements were not satisfied. And that is why the tax court additionally concluded that a charitable deduction would not be allowed, because a qualified appraisal was not obtained. So it was a real double whammy, because the capital gain tax was assigned back to the taxpayer, and he was also denied a charitable deduction. There was a third whammy. It would have been a triple whammy that mercifully the tax court did not impose on the taxpayer, which would have been a substantial understatement penalty, which is a 20% penalty on the understatement of tax. There was clearly a significant understatement of tax because of the capital gain and the deduction that was denied. And if it's more than 10%, that can be a substantial understatement, triggering that 20% penalty. But there are reasonable cause exceptions. And in this case, the tax court said, well, in this situation, the taxpayer had a very competent attorney and reasonably relied on the attorney's advice, although he went down some paths that, he did not transfer the stock well ahead of the agreement of sale, which there was some indication the attorney had advised, and had kind of taken it upon himself who the appraiser would be. Interestingly, the taxpayer said, well, I also relied on this attorney. She worked with the appraiser, the M&A team lead, in reviewing the appraisal. That wasn't good enough to avoid the qualified appraisal issue and deny the charitable deduction. But it was enough, relying on the attorney on the assignment of income issue, that they had satisfied the bright line test at least to get him off the hook for that 20% substantial understatement penalty. That would have really been a
so the
death knell.
The tax on the gain was not avoided.
Right.
The charitable deduction for the asset was not allowed. Right. But that asset still sits in the donor advised fund right now.
The cash sits there.
Yeah.
That's absolutely right. Roughly $3 million and whatever it's grown to or reduced by distribution.
So the kind of the significant penalty, I mean, aside, if he would have kept it in his own estate or in his own ownership interest, and the business sells and he has to pay tax on the sale, he at least would have gotten a deduction for the contribution. So the real penalty, among other things, I guess, but the real penalty was the loss of the deduction, and the icing on the cake would have been the avoidance of the capital gains tax. It's interesting.
Yeah, you're absolutely right. See, the other alternative, and we know, as we, the three of us advise clients, sometimes the business owner or the business owner family is just heading down that one track of getting the deal done. And everyone is locked in on that. Certainly the M&A team is. That's where they're incentivized, and that's what they're good at, as is the attorney who's on the M&A side. And certainly the business owner is looking to optimize what they're going to get for that business. So often the second track of the planning ahead of the liquidity event for things like charitable planning or family legacy planning and so forth are ignored or neglected, or maybe not buttoned down the way the deal itself was clearly buttoned down here. And as a result, in many cases, it's completely ignored or neglected. And then the taxpayer receives many millions of dollars and is looking at, what can I do to mitigate the taxes? And to your point, Steve, often that means writing a check to a donor advised fund or other charity or what have you, and getting the deduction, without having to jump through the hoops of the qualified appraisal or other aspects of using non-marketable securities or cash to fund the charitable bequest. So clearly the path was there to obtain the two benefits, but unfortunately they lost both.
It's interesting, some of the cases over the last couple of years that we've been following. The Connolly case, that addresses the inclusion of that life insurance policy in the estate tax value. And one of the issues there was a qualified appraisal and valuation of the company didn't take place. And here we are back with that. I mean, I think those in the valuation business have some real business opportunities. Not that they didn't before, but this continues to validate the importance of that step in the process, which is often overlooked and not paid enough attention to.
Yeah, I couldn't agree more, Steve. Those two cases, the Connolly case you mentioned and this one, point out the importance of having a great appraiser or appraisal firm as part of the team, as part of the collaborative team. But it's so important that every piece of that team, every member of that team be in place and be working together closely. That was ignored here. And also not to be, penny wise and pound foolish. My heart goes out to Mr. Hoensheid because he wanted to save a few dollars on a very large transaction.
I mean, he had a charitable intention there. It was also doing good for others.
Clearly, and that's why it's so hard to stomach, the result here. But certainly investing a little more toward getting that qualified appraisal would have. I'm sure that his attorney, who by all accounts was a really outstanding planning attorney, had many great valuation firms, just like we do and we work with, and the two of you do as well, that could have been added to the team. So that is really a word to the wise, and for all of us, to, I don't know if the proper term is to stay in our lanes, but to work together and swim together, and to have all the right members of the team working together. So, it's interesting you mentioned the Connolly case, because there was another case 2 years ago in 2023, the Schapler case, where a gift tax return was filed. It was screwed up pretty badly, but the substantial compliance with the requirements of filing the return were followed, and the 3-year statute of limitations that disallowed the IRS from challenging the gift tax return, and it would have been a substantial gift tax differential, was closed to them, that they had substantially complied. Whereas here, the substantial compliance with a qualified appraisal was really there was nothing to pin your hat on. The appraiser had no experience, there was no charge for it, and so forth. So at least with the substantial underpayment penalty, there was substantial compliance and reasonable reliance on an attorney who clearly was competent and was advising the client, and he reasonably relied to the extent of that bright line test that we mentioned. So in some cases, you could really say this is somewhat of a gotcha case, because the tax court kind of strayed from a long-standing precedent of the legal binding obligation being the line. As long as you stay on the right side of that line, well, they did, and the tax court acknowledged that. But now there's some other areas that are, unfortunately, to the discussion we've had today, a little bit on the gray side going forward. But that's the kind of business that we're in, trying to help in the gray areas.
They say smart men learn from their own mistakes, and wise men learn from others. So hopefully these cases, as they stack up, whether it be the Connolly case, the Hohenscheid case, as we have the opportunity to sit down with experts such as yourself, Marty, and talk through the missteps, the advisors and clients listening can say, you know what, I've heard this before. And as they consider the sale of their business, they can reflect and hopefully maneuver around that potential misstep.
Yeah, that's such a great point, Mark, because, it's kind of the phrase, you know it when you see it. Maybe we don't have a bright line now to caution our clients to be careful of, but we know it when we see it. We know that if you're the night before the closing and there's really nothing left to be done, and there's almost no chance that the closing is not going to occur, that you're going to be in trouble. So we know that that's something we have to stray from. How far we need to pull back from that type of a line is hard to say. It's kind of like the planning that we've been advising clients on, all of us, for the last several years, as we anticipated a potential sunset of the Tax Cuts and Jobs Act and the corresponding lifetime gift exemption what do you have to do to make sure that gift is respected as a gift by one party using his or her exemption in a married couple? How many months ahead do you have to split up joint assets and things like that? We don't have a bright line, and it hasn't really been tested yet. So now we have a situation with this type of very important philanthropic planning that so many business owners like to engage in ahead of a sale, where we don't have a bright line anymore, which is unfortunate, but it's also where hopefully we can be of assistance, as you mentioned earlier, Steve.
So those that listen, this is where we come to our I guess, softball question, you could say, not related to tax law or estate planning matters, but more so, let's get to know Marty a little bit more. And I think I have an idea on why you picked this question, coming from your background and your hobbies of being a classically trained singer. Is that correct in saying that?
Well, Mark, the definition of qualified appraisal and the definition of classically trained singer, not sure I would meet all the I could say that I've been classically trained because my best vocal teacher was Frank Sinatra, who might be one of the great vocalists of the last century, and listening to thousands and thousands of hours of Frank Sinatra, in addition to some vocal instruction, actual vocal lessons. But you're right, the question that you have for me does relate to my fascination with Frank Sinatra's music and even singing it sometimes here and there and about town.
So is it going to be a Frank Sinatra song? If you had a theme song to your that could be played to your life in the background, is it going to be a Frank Sinatra one, or who are we thinking of? Dean Martin, maybe? Curveball?
Well, there's some great Dino songs as well, but I think my kind of a life philosophy song would tie in with the Frank Sinatra song, That's Life.
If I was a bet man, I was thinking it was going to be that one.
I think that's something we can all try to live by. Be careful when you're riding too high in April. Just watch out, because you might just be shot down in May. Hopefully, Mr. Hoensheid felt the same way. He was shot down on this, but he's going to live to see another day. He still has a lot of additional assets left from the sale after paying this extra tax he wasn't planning on. But yeah, that's a song I really get a charge out of. I know that's probably why it's one of his greatest hits, Frank Sinatra's, because the lyrics are so
they still hit home.
They hit home
today. Yeah, it's stand strong. Did we miss anything?
I think we covered a lot.
Good.
Thank you so much for being with us.
Yeah.
Thanks for having me, gentlemen. Appreciate it.
Thank you, Marty.
Bye. Goodbye.
The material and opinions voiced are for general information only and are not intended to provide specific advice or recommendations for any individual. To determine what is appropriate for you, please contact a member of our team.